Well, the state of Illinois has responded to Justice Amy Coney Barrett and the Supreme Court in their demand for more information by today's deadline. And this is about their assault weapon ban that's being challenged by the National Association of Gun Rights in Naperville. This is no bueno. Wait till you hear what they're saying to try to justify banning your items. It's crazy. Before I jump into that, I want to thank the sponsor of today's video, and that's Lear Capital. Last year was a terrible year for investors, and predictions are that 2023 will be even worse. But what did have a really impressive year this past year was gold investments. If you're interested in investing in gold, I suggest you call my friends at Lear Capital. The team at Lear will provide helpful information about purchasing gold or converting part of your IRA or your 401k into a gold IRA. Not only are they the best around with over 25 years in business and thousands of 5-star reviews, but they also have a 24-hour risk-free guarantee where you can review your investment for 24 hours before committing to it. You can learn more at leargg.com or call 1-800-260-5075. Thanks to Lear Capital for sponsoring this video. So like I said, the state of Illinois, their attorney general, has given Justice Amy Coney Barrett her required follow-up information to help the Supreme Court decide if they're going to put in an injunction to stop the assault weapon ban in Illinois, in Naperville, to see what if they're going to follow it through for the trial or what. They're just going to let it stand. They're not going to get in the way. Let's start with the introduction, because I'm going to show you some of the things in this, and you're going to see some similarities to 2 other videos I've done in the last 6 days. And this is the new wave of the anti-gun movement. The introduction. In accordance with Justice Barrett's order on May 1st of 2023, the intervener respondent, the state of Illinois, responds to the emergency application for injunction pending appellate review filed by the applicant's National Association for Gun Rights, Robert C. Bevis, and Law Weapons Inc., DBA Law Weapons and Supply. Applicants' extraordinary request to enjoin a presumptively valid state statute while their interlocutory appeal is pending in the United States Court of Appeals for the 7th Circuit should be denied. The applicants have not attempted to make and cannot make the essential threshold showings that this court would be likely to grant certiorari in this interlocutory appeal, or that an injunction pending appeal would be in aid of this court's jurisdiction under the All Writs Act, 28 U.S.C. 1651A. On those grounds alone, the application should be denied. Beyond that, applicants have not shown that it is indisputably clear that they will prevail on their claim that the Protect Illinois Communities Act, or PICA, violates the Second Amendment. Okay. Nor could they, since this court has not addressed a Second Amendment challenge to a law similar to the Act. And after applying the 2-step framework set forth in New York State Rifle and Pistol Association versus Bruin, which there wasn't, 2 district courts have declined to enjoin the Act, and 4 more district courts have declined to enjoin similar laws. These decisions confirm that it is not indisputable that applicants will succeed on the merits of their claims. Applicants have also failed to show that crucial or exigent circumstances exist that would require this court's immediate intervention. Applicants delayed seeking an injunction pending appeal at each stage of these proceedings, belying their argument that they need emergency relief. Then, to support the existence of an emergency, applicants rely on a presumption of irreparable harm that this court has never applied outside of First Amendment cases, again demonstrating that their right to relief is not indisputably clear. Otherwise, they rely on inapposite Court of Appeals precedent that the alleged financial losses of a single gun store, neither of which shows that they will incur irreparable harm absent the injunction pending appeal. On February 17th, the district court denied the applicants' motions. First, the court determined that they are unlikely to succeed on the merits of their claim because Naperville's ordinance and the Act are consistent with the Second Amendment's text, history, and tradition. Really. In particular, the court explained the text of the Second Amendment is limited to only certain arms, and history and tradition demonstrate that particularly dangerous weapons are unprotected. Because assault weapons are particularly dangerous weapons, and high-capacity magazines are particularly dangerous weapon accessories, their regulation accords with history and tradition. So you're going to see some, you should already have seen it if you watch the channel regularly. There's very, very consistent lines here that you've seen in other challenges to the Second Amendment where they want to ban firearms. They're saying that semi-automatic rifles are now dangerous and unusual, which would lump them with the NFA. However, the problem is Congress did not include semi-automatic rifles in the definition. Thus, they're not under the NFA. They are not deemed dangerous and unusual, yet the political talking points now are to keep saying that so that people start to think, wow, ARs, those are dangerous and unusual. How come people aren't paying a $200 tax stamp? Why aren't they undergoing more scrutiny? Why are they allowed to have these? Well, the problem is the government doesn't allow us to have anything. These are our rights. The Constitution is a limitation on government, not us. But they want to just fluff by that. Don't pay attention to that. Let's talk about magazines here. To begin, it is not indisputable that applicants will satisfy their Step 1 burden with respect to the large capacity magazine restrictions because LCMs are accessories, not arms, and thus are not within the scope of the Second Amendment. Have they read the Caetano case? As a historical matter, the term arms referred to weapons and excluded related accessories like ammunition or ammunition containers, which were referred to as accoutrements. In fact, there is ample historical evidence that during the founding era and Reconstruction, cartridge cases and boxes were viewed as accoutrements, not arms. Because LCMs, like cartridge cases and boxes, are containers which hold ammunition, it is not indisputable that they are arms within the meaning of the Second Amendment. Several of the applicant's other sources also do not address whether each of the regulated instruments is commonly used for self-defense, and instead provide ownership or manufacturing statistics, citing the Washington Post survey that 6% of American adults own AR-15 style rifles. Congressional Research Service study indicated that in 2020 alone, 2.8 million AR or AK type rifles were introduced into the U.S. civilian gun stock and trade. Survey stating that AR platform rifles were nearly half of all rifles produced in 2018 and nearly 20% of all firearms sold in 2020. Well, that would mean they're in common use, boys and girls. Not only do assault weapons and large-capacity magazines derive from military-grade weaponry, their features render them uniquely suitable as weapons of war, but not commonly used or suitable for personal self-defense. Assault weapons are designed to allow high-velocity rounds to be fired at a high rate of delivery and a high degree of accuracy at long range. But these features are unnecessary in the civilian self-defense context, where most confrontations involving gunfire are at close range, and therefore do not require the long-distance accuracy of assault weapons. In fact, assault weapons are inherently dangerous in a home defense scenario because they pose a serious risk of overpenetration in most home construction materials. Finally, not only do their characteristics make AR-15s and other similar assault weapons poorly suited for self-defense, they make them as effective on the battlefield, if not more so, as automatic weapons like the M16, which this court deemed permissible to ban. In fact, the most commercially successful weapons regulated by the Act, AR-15 rifles, are M16s in every way except one: the ability to toggle between semi-automatic and automatic fire. In any event, applicants have not shown that it is indisputable that the Act restricts commonly possessed arms, when only a small percentage of gun owners, and even a smaller percentage of Americans, possess the restricted instruments. Nor can applicants overcome the evidence that the Act is consistent with the historical tradition, beginning with restrictions on knives, pistols, and other melee weapons, and culminating in bans on machine guns and other dangerous firearms, demonstrating that categorical bans are contemplated by the Second Amendment. Each of these categorical restrictions, including the materially indistinguishable state and federal restrictions of the early 20th century, is permissible under that amendment. So you can see what Illinois is doing here. They're pushing, they're not in common use for self-defense. Large capacity magazines, they're accessories or accoutrements. They're not protected by the Second Amendment. In fact, these things both, they're dangerous and unusual, and they should be regulated under the NFA. And they're both most useful in military service, and Heller talked about that too. So we can ban these things. So we'll see what the Supreme Court says. Now, this is in the hands of Amy Coney Barrett, and we'll see what she decides to do with this. We'll either have an injunction or we won't, but I would love to hear the court address this with some teeth. But we'll see what happens. But you'll see that there's a lot of similar verbiage in things like we just talked about, the assault weapon ban that was upheld by a state appellate court in California, which has nothing to do with the federal cases. It's like Miller. And you've heard it in other bans where they're saying that, you know, these are dangerous and unusual, so we should be able to ban these right there. We're trying to outthink the Second Amendment. Again, attorneys, man, it takes a special person, it really does. Guys and gals, if you haven't, please check your subscription down below. YouTube's playing a game right now. But my goal is to get to 700,000 subscribers by the end of the year, if not before that. That would be great. My birthday's coming in July, and the end of July, I'd love to have that number closer to then if possible, but all you got to do to help me is to hit that subscribe button down below. That's it. Make me happy, just hit that. I will giggle. Every time you hit that button, just picture me giggling. Guys and gals, until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. We're winning. We really are. It's frustrating. I get it. I'm right there with you. We're winning, and they're grasping at straws. This one's no different. I'll see you on the next one, y'all. Take care.